Right, it's my understanding that we have now heard testimony from all of the approved witnesses. So does that conclude the party's presentation of evidence in this appeal? Ms. Kouemo, does that conclude your presentation of evidence? You're on mute, ma'am.
It does, Your Honor. I believe that I'm not allowed to enter any more evidence. Am I correct?
Well, you haven't made a motion to enter any more evidence, so at this point we've heard from all the approved witnesses.
Mm-hmm. So yes, my answer will be yes then.
Okay, and Mr. Howell, does that conclude the agency's presentation of evidence in this appeal?
And it does.
Okay, so at this point then the parties are free to make a closing argument if they would like to make one. There's no requirement that the parties make a closing argument, but you're welcome to do so no more than 10 minutes for each side. Ms. Kouemo, would you like to make a closing argument in this appeal?
No, we need to that's okay.
That's fine, Ms. Kouemo, you're not required to do so. Mr. Howell, would you like to make a closing argument in this appeal?
Yes, ma'am, I would. I just need 1 moment.
Okay, Ms. Kouemo, does that affect your decision whether you'd like to make a closing? You're still on mute.
Yes, Judge. I wouldn't want to go first. But
you do want to go first?
No, I'm saying I wouldn't want to go first. And if I do make make a closing argument, it's probably going to take a minute. So it's not going to be anything long, or less than a minute even.
Would it be possible to take a brief sort of comfort break before we make them, just to...
Yes, so why don't we let's go off the record.
We are off the record at 5:02 p.m. We are back on the record at 5:16 p.m.
All right, so we're moving into the parties' closing arguments. The parties have agreed that they're both amenable to the agencies presenting its closing argument first. So we will start with Mr. Howell. No more than 10 minutes, and you may begin whenever you're ready.
Thank you. Your Honor, over the past 2 days, you've heard testimony from 9 witnesses, including the appellant herself. Numerous documents have been presented into the record. At every step, appellant has fallen far short of her burden to prove that she made protected disclosures or that any such disclosures contributed in any way to any personnel actions taken against her. As to the first alleged disclosure, regarding idle loans, the best evidence is the lack of evidence itself. Not one witness other than appellant herself has any knowledge of any disclosure or question raised by appellant regarding these loans. Indeed, Letitia Parham, to whom appellant allegedly made the disclosure, has no memory of them. More importantly, no supervisor with any actual power to take a personnel action knew of it. Most fatal of all, though, is appellant's own lack of knowledge about the disclosure. Under oath, she could not provide any specific details underlying the alleged disclosure. Indeed, appellant could not explain with any specificity how the agency's actions related to idle loans violated any law. As to the second alleged disclosure, regarding the use of the versions of IRS Form 45016, the evidence clearly shows that the agency reviewed appellant's questions and it provided an answer. Appellant's own testimony about this alleged disclosure also undermines her case. Appellant acknowledged that she simply disagreed with the agency's policy decision regarding which form to use. Thus, appellant fails in her first burden of showing that she made a protected disclosure at all. Appellant also fails in her burden to demonstrate that any alleged disclosure contributed in any way to a personnel action. Notably, no one but appellant remembers the first alleged disclosure relating to idle loan rule changes. The knowledge timing test cannot possibly be met when knowledge is lacking. Indeed, Ms. Parham, who allegedly received the first disclosure, and who was not even a supervisor, had no memory of it whatsoever. And Ms. Parham also testified that she held no animus toward appellant and even served as a reference for her. The same was true for the rest of the witnesses, save Appellant herself. Appellant repeatedly asserted that she had evidence that other management officials knew of her purported disclosure, yet she never introduced said evidence. As to Appellant's second disclosure regarding IRS Form 4506T, the evidence shows that Appellant's team lead raised Appellant's questions to management. Management answered. Neither Ms. McCall nor anyone in management held any animus toward Appellant for raising the question. Ms. McCall testified that management encouraged questions. Indeed, as Ms. Holloway, who testified that she always found Appellant to be smart and to be a person who asked good questions, testified that questions about the use of that form were not only rather common, but that the IRS had actually instructed the agency to use that specific version. And Ms. Holloway noted that no one suffered retaliation for asking such questions because, in fact, there were so many of them. Ms. McCall stated that no management officials expressed any negative opinion of the question raised by Appellant. Indeed, Mr. Martin didn't even realize the question came from Appellant. Despite Appellant's contention otherwise, even a thumbnail picture of her just didn't ring a bell with Mr. Martin. Appellant therefore failed to meet her burden of proof to either demonstrate a protected disclosure or show that it was a contributing factor in any action taken against her. As a result, corrective action cannot be ordered. But even if Appellant met her burden, which she did not, the agency also proved by clear and convincing evidence that it would have taken all of the actions it did against Appellant, even in the absence of her alleged whistleblowing. First, the undisputed evidence showed that Ms. Rivera contacted Appellant while she was on sick leave in June 2020 because there was a policy that permitted her to do so, and because Ms. Rivera had certain questions she had to ask given the ongoing COVID-19 pandemic. As you heard from Ms. Rivera, this was a policy on which she acted, and a policy that she applied to Appellant in the same way she has to other employees. Even Appellant acknowledged that her team lead did not deny she was sick, wished her well, and simply told her that she would need to obtain a note from her doctor to return to work. And Appellant also had to admit that the very language of the regulation she alleged the agency violated in contacting her, actually permitted it to contact her. Once more, Appellant produced no evidence that Ms. Rivera had any knowledge about her disclosures related to rule changes for idle loans. Next, the evidence showed that the transfer of what Appellant repeatedly called a simplistic data entry task was simply based on agency need. Indeed, you heard from several witnesses that it is a common practice in the Office of Disaster Assistance to move employees around based on agency need. You heard from multiple witnesses about the importance of this work to SBA's mission at the time. More importantly, Appellant also admitted her true reason for complaining about the task. Namely, Appellant felt it was beneath her because she is an attorney. Her own undisputed words, which she admitted to, showed that she felt it was work she should not have to do simply because she is an attorney. And as detailed before, Ms. Rivera did not know of Appellant's first disclosure. Then there's the issue of Appellant's being charged AWOL. You heard from several witnesses, including Ms. Rivera, Mr. Martin, Ms. Holloway, Mr. Chung, and Mr. Goodson, that the policy in ODA at the time required employees to submit leave requests ahead of time, except in the cases of unplanned leave, such as sick leave or true emergencies. The undisputed testimony, including from Appellant herself, is that ODA was very busy at the time, so much so that employees had to work mandatory overtime. In fact, several witnesses detailed that when an employee took annual leave, that employee then became ineligible for overtime on that date, resulting in hours of lost productivity to a very busy office. What happened is that Appellant repeatedly failed to follow the policy. Appellant received verbal counseling from Ms. Rivera and Mr. Martin about the policy. Ms. Rivera invited Appellant to provide reasons for her absences. Appellant readily admitted that she was not at work, and she refused to provide details for one 2-hour period, which she only described as a personal emergency. In fact, as Appellant now admits, the so-called personal emergency was simply her applying for another job, all during the period of time when she was committed to work for the SBA. Appellant never mentioned this to the agency, even after it asked her for an explanation multiple times, and she also didn't explain it in this hearing until pressed to do so on cross-examination. Perhaps most importantly, though, appellant admits that she was not at work during the times for which she submitted these after-the-fact leave requests. Appellant also admits that she withheld information as to the true reason for her absence in at least one instance, even after being asked by management. The evidence showed that the agency gave appellant every opportunity to appeal the AWOL determination. Ms. Rivera and Mr. Martin even told her how to do so, as can be proven during one of appellant's 2 surreptitiously recorded phone calls. Moreover, as Mr. Chung testified, the agency considered the totality of the circumstances surrounding appellant's multiple instances of attendance issues in a short period of time. What's more, the undisputed evidence shows that Ms. Rivera, Mr. Martin, Mr. Chung, and Mr. Goodson all had no knowledge of appellant's alleged disclosures about idle rule changes. Appellant also alleges that the agency refused to provide her with a performance review and refused to evaluate her performance. Appellant was unable to detail specifically who refused to provide the information, and as we heard from Mr. Martin, the same Mr. Martin who had no knowledge of appellant's first disclosure, he directed any such questions to HR personnel. Additionally, as you heard from Mr. Goodson, an employee who leaves suddenly may interfere with the agency's ability to utilize its typical offboarding protocols. More than a year after her resignation, the same resignation for which appellant provided literally less than a minute's notice, appellant has belatedly chosen to allege that the agency constructively terminated her. The evidence belies her claims, however. Her own resignation email shows that she made no mention of the resignation being anything but voluntary. As noted numerous times throughout this hearing and throughout the record evidence, no one but appellant remembers her first alleged disclosure. An appellant chose to resign only the next day after the agency management answered her questions about the version of the IRS tax form, albeit in a way with which appellant disagreed, even as such determinations were not within her purview. The rest of the actions taken against appellant were consistent with policy. As detailed at length, the AWOL charge was based, in large part, on appellant's own admissions. Appellant has not and cannot show that her resignation was involuntary. Appellant has made much in this hearing of what she deems to be conversations regarding a possible termination. As it turns out, to the extent any such conversation might have happened at all, the agency deliberately chose not to move forward with any such potential action, precisely because it felt it had not fully counseled her yet and wanted to be fair. More importantly, though, appellant knew nothing of any such conversation until discovery in this case. Thus, it cannot possibly have played a part in her decision to resign unilaterally with no notice. Put simply, she cannot show her resignation to be the product of coercion, misinformation, misrepresentation, or deception. The evidence shows that the choice to leave was appellant's, a choice she exercised freely and with absolutely no advance notice to her employer. Finally, appellant...
That's time, Mr. Helms. All right, thank you so much. All right, Ms. Kouemo, 10 minutes for your closing, and you can start at any time.
Thank you, Judge. Actually, listening to Mr. Howell's closing arguments, I feel very unprepared. So I am just going to say that the evidence that is submitted in the record, I believe, speaks for itself. I also believe that the testimonies that we heard throughout this hearing also provide some light into my protected disclosures and personal actions that were taken against me. And I am just asking that the judge does hold the agency accountable for their actions against me, and that justice be done in this case. And that's pretty much it.
Okay. All right. Thank you, Ms. Kouemo. And thank you, Mr. Howell. So I believe that concludes the hearing in this matter, and I declare the record in this appeal closed. The time is now 5:29 p.m. Central Time. Let's go off the record.